Welcome to the Case Autopsy, the Verdict and Settlement podcast with your host, Mike Campbell. Case Autopsy is part of the family of podcasts brought to you by Lawyer Minds. In this podcast, we explore recent verdicts and settlements from around the country to try and distill down the best techniques for you to apply in your cases. Here's your hosts, Mike Campbell and Chris Finney.
How you doing, man?
Good, brother. How about yourself?
No complaints on this end. We've got a beautiful day. It's fall officially. Well, at least feels officially fall.
Yeah, it's officially, I think, fall.
Okay.
Yeah. You're getting some nice results.
Well, thanks. I mean, I appreciate it. They're only on paper for some of them, so you got to collect. But you guys are doing pretty well yourself. Your firm's growing at, it seemed to be, a rapid pace.
Rapid pace. Yeah, we're adding new lawyers. People are asking to come aboard. It's a nice problem to have.
And good people are asking to come on board.
Good people, good lawyers, people with a lot of experience and who have their hearts in the right places.
Yeah.
One thing I'll say about, you were talking about on paper, you guys that go into courtroom and you ask a jury for money and they give it to you. And so I see sometimes people advertise like, here's all these judgments we have, and they really are on paper, right?
Yeah.
But
judge signed off on a piece that somebody didn't even show up for.
So I don't want you to discount. I know you're not, but man, you're putting in the work. And let the cat out of the bag here. We're actually doing this, recording this intro after we talk with Nolan. Mm-hmm. This is going to be a really long podcast, but an awesome podcast. We might break it into two because halfway through, we all of a sudden start going down to this different path.
Yeah.
Where we start talking about Nolan's experience as a juror.
Which I thought was it's not the biggest takeaway, but it is a really good reminder of how a juror is taking in a case they're totally unfamiliar with. And He pointed out some basics of, hey, we need to, how can we help? And all, like when you're a juror and you're leaning towards the side, but also he pointed out, and you'll hear about it, is he's aware of all the biases that people have when they come into being a juror and how you're not supposed to, allow those biases to take effect or set them aside. And he was like, I found myself leaning towards the side, even though knowing I'm not supposed to till the end of the case.
And I think I remember when I interviewed your Uncle Don for the magazine, you told me this is a guy who is in the instructions, right? And he knows the elements. And I think sometimes we get caught up in a lot of the flowery stuff, and sometimes we need to, like you said, just make it very basic.
Yeah, you're right.
I know for me, I got to get out of my own head and make this just very basic. What are we wanting this jury to do?
Yes.
And I love that Nolan talked about that.
And he talked about it. And for those that don't know, Nolan Drafahl is one of, I would definitely consider him one of the up and coming lawyers in Missouri. He's incredibly bright. He's a very hard worker. He knows there's basically not a trial strategy or school of thought that he's not familiar with and studied in depth and can recall it, the drop of a hat. So he's a guy who really puts all those things together. And in this case where they had a $0 offer and returned a $3 million medical malpractice verdict, it's pretty interesting to see how they went through it and the mechanics, logistics, things like that. So it'd be
Got to break it down, and it's going to take a while, but it's worth it. And so whether it's one whole thing or a couple of parts, encourage you to strongly stick with it because the conversation I think is really beneficial. So let's roll.
You're listening to the Case Autopsy, the Verdict and Settlement podcast. This is Mike Campbell.
Hey, Nolan, how's it going, man?
Going well. Thanks for having me.
You got it, buddy. Hey, tell us a little bit about your practice.
Sure. So I'm a solo practitioner here in St. Louis, Missouri. My practice is devoted exclusively to personal injury matters, and most of those are motor vehicle collision cases, car, truck, motorcycle. And then, I'll handle some outside the box cases from time to time, some premises liability cases, things like that. And recently, I have had the occasion to get involved in a few medical negligence cases. And I think we're obviously here to talk about one of those recent trials.
Just dabbling, Chris. He's just dabbling in medical malpractice cases.
And it's like people who take on medical malpractice in Missouri, for most of the listeners, don't realize the kind of caps that we have, and just exclusive of the caps, the juror bias going in.
Right. And then Nolan's like, I'm gonna dip my toe in these waters, and I'm gonna get some significant results, which speaks to Nolan's trial abilities, I think. So,
which is why we're here, which is the case we're going to talk about, which Nolan, you and co-counsel Jeremy Gogol obtained a $3 million jury verdict about 2 months ago, maybe.
Month and a half, 2 months.
On a failure to diagnose case, an emergency room visit for basically a headache, right?
Yeah. In essence, we represented a mother who lost her 24-year-old daughter. Her daughter's name was Jasmine. Jasmine left behind 3 young kids. But yeah, she goes to an emergency room. She says, I've got a headache that's lasted a couple days. She rated it as 8 out of 10 pain. And she mentioned that she was also having photophobia, which means basically, bright lights were bothering her, and also spotty vision, which wasn't really fleshed out in the medical records. But the issue, though, was she was also having a runny nose. She was sneezing, and she had watery eyes. And so the emergency room physician ultimately gives her a migraine cocktail, observes her for a couple hours, and then discharges her with the diagnosis of sinusitis, which is essentially a sinus infection. And
I got one of those right now.
Yeah.
Well, hopefully that's all it is, Chris, and hopefully you get diagnosed by this doctor with that.
Exactly.
So
he sends her home, right? And nothing happens for is it a few days?
Yeah, so she gets home and she is still having these headaches, and they're pretty bad. I think she was somebody that had a higher threshold, kind of pain limit. Wasn't really much of a complainer, and maybe even underreported. Maybe you or I would go in and say it was a 10 out of 10 headache. Anyway, she gets home. She's not feeling well, but she trusts the diagnosis. The next couple days, she kind of rests. She's laying in bed. It's still bad. And then on day 3, which was a Friday, okay, so she went in, saw this doctor we were talking about on a Tuesday. Friday morning, her clinical picture changes pretty significantly. It falls off a toilet a couple times, so she's having balance and coordination issues. Her roommate, says she's acting all funny and is trying to kind of hide this. She was walking around the house naked, which was very unlike her. And so now, she's kind of exhibiting a lot of hallmark symptoms of something more serious. Okay. So her roommate calls for an ambulance. An ambulance takes her to a different hospital. The different hospital does a head CT scan, which reveals a massive frontal lobe brain bleed.
Oh.
And ultimately they do a CT angiogram while she's still there. There's a lack of blood flow. She's unconscious. They were never able to determine the source of her bleed, in terms of what vessel it would have, originated at or anything like that. And unfortunately, she dies at that hospital on Friday.
God, that's awful.
It is.
Boy, that's a horrific story, especially with 3 children that are left behind at a young age. But also, I mean, we say this a lot about malpractice cases, but that case comes in my door, and I immediately am thinking, all right, there's a serious causation problem here. We've got 3 days of, she went on Tuesday, she's back Friday. I mean, how in the world are we going to connect them? And then even if they did discover anything, how would it even change the outcome? How accurately did she report her symptoms? There's just a lot of questions that I have as a plaintiff's, I'm pretty biased as a plaintiff's lawyer. I mean, when you guys had looked at those issues, I mean, you guys know what you're doing. You see those issues. What was your immediate feel on the case? Because I know you came in later to help try the case with Jeremy and also do a lot of the damages stuff, right?
Indeed.
Okay.
Yeah. So Jeremy, and to kind of take a step back, and not toot my own horn too much.
Toot away, Nolan. Toot away.
Well, when you said, Mike, like, oh, Nolan's just dabbling in medical malpractice. Jeremy, my co-counsel who brought me in to help try this, he's also a solo practitioner. Obviously, trying a week-long medical negligence case by yourself, that would be ludicrous. Okay,
not great.
But he does a fair amount of these cases. He's brilliant, very smart, knows medicine very well, knows the law exceptionally well, and I did come in late, like Chris said. I probably came in 9 months to a year before trial, so I actually sat through a couple of the defense expert depositions that Jeremy did. And so, it wasn't like I came in the week before trial, for instance. I was able to get my arms around the case and be involved in some of, of course, the strategy as we got toward trial. But yeah, so to answer your question, Chris, on one hand, that timeline, the Tuesday to Friday, was what I thought was one of our strongest, pieces of circumstantial evidence, right? On the other hand, we had to prove our case entirely through circumstantial evidence, right? Because on Tuesday, because the doctor didn't order the CT, the head CT that we said he should have ordered initially, we don't know what it would have shown. Right? It was speculative. Okay, so we never got those results, and so as you might imagine, the defense was, well, hey, how do we know there was already a bleed on Tuesday? And if there was a bleed, how do we know it would have been detected by a head CT scan? Oh, by the way, if there was a bleed, how do we know that any sort of operational intervention would have actually made a difference here? So to answer your point, Chris, we had a neurosurgeon opine on those issues, and he did what he could. Of course, there is speculation involved, but ultimately he said, within a reasonable degree of medical certainty, I believe there was a bleed going. I believe it was a small bleed. Okay, there's something, if somebody has the type of bleed like a subarachnoid hemorrhage, for instance, there's a term called a sentinel bleed, okay, which is essentially a warning bleed before the bleed gets bigger and grows and starts causing all of these symptoms that are hard to undo due to the
hence the name. Hence the name, sentinel bleed. Yeah,
exactly. So he says because of the lack of her headache history and that she's there and the symptoms and the spotty vision, which was kind of a point of contention, he thinks there was a warning bleed. And he said head CT scans are so sensitive to bleed that even if it wasn't bleeding yet, let's say it was an aneurysmal bleed, if there was even a aneurysm at that point,
which is a collection of aneurysm is a collection of blood, right?
Yeah, essentially a pooling of blood in the vessel, and then of course a ruptured aneurysm is when the vessel ruptures and the blood leaks out. So those were his opinions, and so that's kind of what we had from an expert standpoint. His last opinion, of course, was, because I think it was just an aneurysm or maybe a ruptured aneurysm, but not affecting her, too much, right? She had these symptoms, but they're fairly benign. He thinks that, this hospital could have brought in a neurosurgeon. They could have operated, and that she would have had very little and maybe no neurological impact from the operation. So
they could have tied off the aneurysm or whatever, and she would have been pretty much fine.
Yes.
That still sounds like a really difficult case to me, Nolan. I mean, that sounds tough.
Well, and to your point, it was a no offer case.
Yeah.
They never made an offer. Yeah. They never made an offer even during trial, after closing or anything. I mean, we thought we put on a heck of a trial, but I think they had kind of made up their mind on thinking it was a very defensible case, especially in light of, it was in St. Louis County, which is a fine venue. In terms of just kind of the dynamics, our family, our client was African-American. the doctor was a very well-appearing white doctor. If he wasn't a doctor, he would have been a male model. He was like sick. And that's the thing too. I come in late. Jeremy had already taken his deposition, and then we get to trial, and I see this guy for the first time. I'm like, geez, Jeremy, you didn't tell me this is like, some dude from Central Casting. Why couldn't he be some schlubby, like,
Right.
why couldn't he look like my primary care doctor or the
Right.
usual doctors I see? So, and he presented very well, and he sounded very, thoughtful and caring and all those things. And our jury makeup was, 11 white people, 1 African American. So you never know with those dynamics if, people kind of tend to relate to somebody that looks more like them or whatever. But I don't know if that played into the defense's decision not to make a settlement offer, but there are bigger things at play, like, again, the lack of direct evidence on some of this stuff.
Well, and so obviously, for those that don't know, in Missouri, for medical negligence cases, including the death cases, there are caps. So this isn't, I know you're kind of a fan of sometimes putting in or not putting in special damages and going strictly with non-economics in your other types of cases. How did your approach differ this time around?
Yeah, so we had an economist who projected past and future lost wages and, the loss of household services going forward. So our client's daughter was making, about $15 an hour and stuff. So despite her young age, the total economic damages weren't crazy high. They were $845,000 roughly. Mm-hmm. That includes past and future. So we put that in because you have to put in the economic part is the part that is not capped in Missouri. Okay, so you want those economic damages in. The part that is capped is the non-economic damages. So our legislature has determined for medical negligence cases that a severe injury or the loss of a life is only worth $770,000. Okay, so the jury does not know that. Okay, so in this case, we asked for $2 million, right? We didn't want to ask just for the bare minimum. We thought it would be kind of, insulting, if nothing else. So we thought that was a number that sort of respected the situation, but also wasn't going to be something that would be too off-putting. Mm-hmm. For a jury, like in that they would think it was so high, and we would be like, man, maybe we should ask for a little bit less, knowing that we're ultimately going to be capped. So what ended up happening was, and we can kind of, this is getting to the end of things, but what ended up happening was the jury gave us every dollar of the economic damages, and then for the non-economic, they actually gave us slightly more than $2 million. They rounded up so that it was an even $3 million. So instead of giving us $2.845 million, they wanted, I think, to send a little bit of a message and round it up to an even 3.
And was unanimous or not? I mean, Missouri 9 out of 12 does the job, but what was your guys' split?
We got to 9, and what we learned afterward was, and they were out deliberating for about 3.5 hours. And we knew we had some people, because jurors in Missouri are allowed to submit questions to the judge. They're allowed to ask for exhibits, evidence. They can ask for anything they want, but we can only give them, evidence that's been admitted. And what can be frustrating about these questions is, usually the judge's response is simply, you will be guided by the evidence as you recall it. So one of the questions we got was, we are having heated discussions about which expert said what. And I'm like, well, hey, heated discussions is good. That means we got some people fighting for us, right? But, of course, you just have to send back, you will be guided by the evidence. So we figured, man, if it was heated before, it's probably going to be even more heated once they get that back. But what we ultimately learned was that 7 people were for us right away. And they were able to talk 2 people that were kind of on the fence over to our side. And So we got there 9 out of 12.
I mean, an initial 7 is a strong start. Like, I'm always a believer that if you get 4 strongly in your favor that are not going to budge, they'll do some swaying. But you guys must have done a heck of a job to get 7. And this was a week long, just a week, Monday to Friday.
Correct.
Was there any concern about? So talk us through strategy leading up. So timing. How long did you want the case to go? You know, you and I and Mike have talked before about speed trial type stuff, things like that Joe Freed talks about. I know a lot of us are trying to do that in our cases, but you know, it's different when you're doing it in an auto case versus a medical negligence case. Were there things of that nature you were trying to implement, and did you have to leave things on, you know, the editing room floor where you're like, it's just not, we don't have time or it's not worth it? What were the in-game strategy developments, things like that?
Yeah, we thought that we probably wouldn't start evidence till Tuesday, and that's what happened. So, you know, by the time we got the panel for jury selection, I think our panel was 60 people. By the time we got that, it might have been 11 in the morning, something like that. On Monday, my jury selection was probably 2.5 hours. The defenses might have been 45 minutes to an hour. And then we did opening statements on Monday. And then so Tuesday, so to answer your question, Chris, there wasn't a lot of speed, you know, we kind of knew we had to put on these experts, and we knew we were going to play some of their experts deposition in our case in chief, which was a point of contention for other reasons. But we were hoping to get it done that week. The biggest thing, of course, was we did not want to give the case to the jury at like 4 p.m. on Friday or something like that, right? But as we got closer, you know, as we got to Wednesday, Thursday, we felt comfortable that we would finish pretty early Friday. We would be able to close either right before lunch or right after. And we ended up closing and finishing at 1:30. So it was right after we took an early lunch. And we felt okay about giving the jury enough time. And they returned the verdict right at about 5 o'clock.
So was everybody live, the experts, or were some videoed? How did that work? Our
neurosurgeon, who I referenced earlier, we just played portions of his video deposition. He was
there's some thoughts behind, like, explain. There's some strategy behind that, right? That was your guys' decision, and tell us why.
It was. I mean, he's an older gentleman. I think he's, you know, upper 80s at this point, and just didn't present super well, at least in our opinion. And I'm trying to be kind of careful with what I say. Well, this is, you know,
recorded,
still pending, and stuff like that, and whatever. But you know, he gave a bunch of standard of care opinions. But one strategy decision we made was, we don't need him on the standard of care. We have a standard of care ER physician doctor as a separate expert. Okay, so those were our 3 experts. We had an economist on damages, the neurosurgeon on causation and, you know, whether treatment would have helped, and then an ER expert to actually discuss, you know, the standard of care for this emergency room doctor. So we're like, you know, why don't we just try to cut his stuff down? And I think we cut it down to like 13 or 14 minutes.
Okay.
And we played that to just hit those issues on causation, right? Because as we saw it, that wasn't totally controverted. I mean, their biggest points pushing back on us were more of the standard of care stuff. So that's kind of what we did there. And they played a much longer portion of the neurosurgeon deposition that more talked about bias, the fact that he hadn't done a brain surgery since 2011, that now all he does is medical legal work, that he advertises for his services, that he does more plaintiffs than defense. So we let him do that. It played probably 35 minutes worth of that stuff. And, you know, as it was played, we thought the jury looked kind of bored. And again, it wasn't something we were super concerned with.
And this comes up a lot. Did the judge make you play those clips all together? In that, I mean, you had 13 minutes, they had 40 minutes or whatever. Did you have to play one 53-minute clip, or did you play yours, stop, and then have them plug in and play theirs? How did that look? Because I'm always concerned. I don't want the jurors to think I'm sponsoring any of their.
Yeah.
How did that play out?
Good question, Chris. And you probably think I'm crazy with this just only happening a month and a half or 2 months ago, but I don't remember. I can tell you this. We did not just play it as one clip. Okay. So either we played our part and then they played their part in their case in chief, or we played our part, we stopped,
they played their
and
cross.
we said, now we're playing the defense's designation. But I think it was actually that we just played our part and then they played the other part in their case.
Oh, in their case. Interesting. So
that's very interesting.
Yeah.
Mm-hmm. Been there, done that, huh, Chris?
Yeah. It's always leads to a nice fight. Wait, you're not playing all of our cross-examination designations? No, they're an hour and a half. I have 12 minutes.
Yeah.
You can plug in when you want.
Yeah. And I remember that coming up at the pretrial conference and there being some back and forth about that. So I believe that's how it actually panned out. And our judge was very good. He was his pretrial motions mostly went in our favor, and I think they should. In other words, sometimes what we see is that some judges, if they're giving you a lot of, pretrial motions, right? They're granting your motions or whatever. It's almost like they think like, man, maybe I'm giving this party too much and I need to appear more fair. So he didn't do that. He looked at everything on the merits and he had no qualms about, just ruling how he thought he should and taking, setting aside, I guess, any sort of appearance of one party winning a lot of motions and the other party not.
So I'm interested in this. You talked about, you had an expert on causation, which was the gentleman who talked about the potential for a brain bleed early on that Tuesday, the sentinel brain bleed. And then you had a standard of care emergency room doc, or standard of care emergency room doc. How did that gentleman present, or gentlelady or gentlewoman or whatever? How did that doctor present to the jury?
He did fine. He flew in from North Carolina, and we put him on as our first witness on Tuesday.
Tuesday morning, he's first up.
Correct.
You open, or Jeremy opens, I guess. Is that how you did jury selection?
I opened.
You opened. Okay.
I did both, and we did both on Monday. And so Tuesday we start evidence, and we start with this doctor. And he presented well. But Mike, one thing that we always knew he would do fine, but a strategy decision, or kind of how we saw this case going, was their emergency room doctor expert was super well credentialed. Okay. Harvard, tons of publications, had written about this issue so many times. And Jeremy did a deep dive into everything this guy's ever written, probably read through 20 of his depositions, and took a fantastic deposition of their doctor, okay, where he got a ton of concessions. And so knowing that, and knowing kind of how this guy was going to be boxed in, for lack of a better term, we really thought that if we were going to win this case, we were going to essentially win it through their expert, right? Because of course, the jury's going to see that both sides are paying experts, and so you lose maybe a little bit there on the credibility. But if we can get their expert, who should be biased in their favor, to say things that are good for our case, that's really where we want to put a lot of our energy.
So some judo law type stuff, kind of turn some of their stuff back on them that was in the records and stuff, or what?
No, not as much in the records, more about just what this guy has written. So, for instance, Jeremy got him to acknowledge that acute headaches are actually unlikely in connection with sinusitis. So I know a lot of us think about sinus headaches and sinus pressure, and I think those things obviously really happened. But in the emergency room setting, for somebody that's going to an emergency room with 8 out of 10 headaches and other symptoms, right? He's like, actually, we find that sinus infections are very rarely the cause. And so he opined that that was likely a misdiagnosis. And what was more likely, okay, was either a migraine or potentially a small brain bleed. Now, he said it would be much more likely that it was a migraine, especially on a younger woman at that time, you know, even in hindsight, knowing what ultimately happened that Friday. But the other thing is, he said, in an emergency room setting, you are not just supposed to rely on the diagnosis of a migraine unless somebody has had, I think, 3 to 5 attacks that are similar, okay? So unless they have an established history of migraine or migraine-related headaches, you're not supposed to just rely on that. Instead, you should have more serious things on your differential diagnosis, right? Which, for those that don't know, it's essentially like a doctor's checklist when they're trying to triage things and narrow things down, right? They're supposed to rule out the worst things first, and then hopefully rule those things out and get to something more benign. But the way you would rule out something more serious in this setting is by a simple head CT scan, okay? And the head CT scan is right there at the hospital. It takes 5 minutes after the tech sets it up. It, you know, it involves a trivial amount of radiation, et cetera, right? So that was kind of our whole point, was, you know, you've got their own expert acknowledging some of these, and in the record, it said that our client, she denied any sort of history of headaches, which probably isn't literally true, but what we said was, well, in that setting, it just means, you know, I've never had a headache like this, right? Or never had a headache this bad before. And so when somebody says that, and they don't have an established history of migraines and sinus headaches are unlikely, where does that leave you? You know, you should have these things on your differential, and you should do the head CT to hopefully rule those things out.
And you got all those things, the concessions, the strategy was, we're going to hit the expert doc on their side with these things. Basically just one fact, one question. Let's get these admissions and then tell the jury, hey, look, their own expert agrees with the following.
100%. And Jeremy did it masterfully at trial too. I mean, it was just, yes, right?
Bang.
Did great. Now, the expert, of course, walked right up to the line, but then ultimately said, but I don't think this was negligence. This was an issue of clinical judgment. Sure, it wouldn't have been malpractice to do a head CT, but I also don't think it's malpractice not to do a head CT. I think obviously when you've got a runny nose and watery eyes and sneezing, and those symptoms supposedly came on with the headache, you know, I don't think this was, you know, outside of the standard of care.
But then you got your guys basically to kind of carry the weight over the hill there and get you to that 51%. That is, so you did 2.5 hours of jury selection, went 5 days, and then they had 2.5 hours out deliberating, or did you say 2.5, 3.5?
3.5, I think.
Man, I tell you, this sounds like a really difficult case. Sounds like this is excellent lawyering, Nolan. Excellent.
Thanks. Well, again, I mean, I can't, you know, say enough about my co-counsel, Jeremy. It was his case, right? I came in and helped, you know, I think jury selection went well, opening went well. So we were really happy after day one. And then our plaintiff was fantastic. I directed her. I had spent time in her home, took photos of a bunch of different, you know, photos she had on her wall of Jasmine and the kids and, you know, things like that. And all of those, you know, I kind of had them in a PowerPoint. And so while I was directing her, you know, instead of having really form-based outline, you know, we kind of got through some things, and I was like, let's talk about Jasmine, and had the photos in order such that, like, you know, we could talk about what she was doing with her kids there, things she liked to do, hobbies, you know, and it brought the jury to tears. she's just a remarkable woman. And now she's basically, she goes from grandma to mom raising these kids.
Yeah.
And so having a good plaintiff is very good, believe it or not.
Yeah, I mean,
that's kind of important.
Very. And she acted as an ex-friend for the kids, correct?
Yes. Yeah. She was she was the rep on behalf of all Class 1 beneficiaries.
And then, so aside from that PowerPoint, did you have any other visuals that you guys utilized, or was this more like, hey, let the jurors do this in their own minds?
Yeah, well, I mean, throughout the case, yes, we had, obviously the medical record was belabored, by both sides. The defense on that issue, by the way, was, and this kind of comes back to framing and case strategy, right? So they wanted to make this case all about something called a thunderclap headache, right? Which is when the pain comes on so suddenly, it reaches its apex very quickly, and it's debilitating. Often there's a quick decline, and you start picking up other symptoms. So their whole thing, they got this big easel out there, and they're like, altered mental status, loss of consciousness, neck pain, nausea, vomiting, blah, blah, blah. All of these are negative. And by the way, she had this head pain for 2 days. Usually when we see the thunderclap, these people are at the hospital within a matter of hours, And so we're like, well, our point there was like, that's the hallmark situation. And, you or me could order the head CT, right? Like,
I know that. Yeah. You show up and you're throwing up from a headache. You got some serious issues that just showed up 2 hours ago.
It's interesting that you're talking about this, Nolan, because I'm thinking about this case that Chris and I was texting Chris about beforehand, just thinking this through. It's like when you reframe something, right? And I mean, it's something like seems very obvious, and then you reframe it, and all of a sudden it's like, whoa, light bulbs, right? Just do the CT. What's it? What does it hurt? Just do the CT.
Yeah, and so we, one of my points in closing, and kind of a point through, cross-exam of the doctor too, was like, I mean, how often do you have a situation where like you get the warning bleed, right? There is that chance of early intervention, right? So my whole point was, they did this whole thing in closing, and I did the rebuttal close, and I was like, listen, like, on Friday she had all those things, but on Friday it's too late. Like, the whole point of this case is you have a patient coming and talking to you and trying to tell you through their symptoms something's wrong. Like, you had a chance to save her. You had a chance to save her through a very accessible, easy, harmless test. And you guys know it. Like, you see these CT scans are ordered like they're given out like hotcakes at hospitals,
Surprising it doesn't happen in the ER when somebody comes in with head pain. They just run them through.
Quick insurance hit.
Right? I know. And so Anyway, so in terms of visuals, Chris, there was with our economist, went through her report and stuff like that. The medical record was up there a lot. We did show CT images of the brain from that Friday where it shows the massive frontal lobe bleed, and talked about that.
But no like time lapse bleed thing like that. It seems like, and I don't want to judge your neurosurgeon expert too much, but it seems like, just what you've said, he may not have been the most sophisticated to utilize an animation or something like that to walk it through with the jurors.
Correct. Yeah. So we went through the head CT from Friday with him briefly, but that was the only visual we used with him. And we did, so I did a PowerPoint for my opening, which I'm.
Oh, you did?
Okay. Yes. A big proponent of that.
Any pushback on it?
No. So the judges deal with opening power. So first of all, we filed a pretrial motion to utilize visual aids during opening statement, and that wasn't really opposed. In fact, the defense was thinking about doing one. They ultimately decided against it and opted for the easel and like a flip chart. But the judge's rule was like, hey, anything you're going to show the jury in opening, you have to show defense first. And so I'm like, all right, like, that's fine. And so we did it, and no issue.
Yeah, and that PowerPoint, because I've been toying with that idea more. We did it in the last trial, but but I only had like 4 slides, just to kind of identify people, things like that. What was your thought process with your PowerPoint? Obviously, you're going to be dealing with medical terms, likely foreign to the jurors. You're going to have maybe images of the CTs up there, and then you're going to have a damages portion, maybe. I mean, how many slides, words, pictures? What were you thinking with it?
So I think there were maybe 20 slides, and in terms of the number of words per slide, it wasn't a lot. And the reason there's like, and I'm, by the way, like, I'm not going to be the first person to say any of this stuff. I've learned from so many different, trial gurus and stuff. So I'm just trying to kind of incorporate what makes sense to me. But one thing that did resonate with me is if you've got a bunch of words on a slide and you're presenting the slide while you're also talking, the jury is going to kind of have this tension of like, am I supposed to be listening to Nolan's words, or am I supposed to be reading what's on the screen, right? And so maybe they're not even absorbing stuff well. So pretty minimalist, black background, bold white font, right? That is going to be easy for the jury to see with the contrast, no weird color combinations, no animations with like the text coming in all funky.
Yeah.
And really my thought was this, okay, I wanted to do a fairly short opening. So it was 20 to 25 minutes. And I did just, as I told Chris this, and I want to talk about this briefly, but I was actually called for jury duty and selected as a juror like a couple weeks ago, which was,
Awesome.
It was good. So I wanted to keep it fairly simple. And I also told the jury, like, this is a simple case, right? And then I wanted to live up to that and kind of try to distill it down to its essences. And so my thought is this: obviously I'm on camera, so people who are just listening to me, what I'm doing is kind of just doing a flat line with my hand. And my thought is, if you are just talking without visuals, the jury might not know, like, what's the real important stuff. Like, out of this 20 minutes you're telling me, like, what do I really need to remember? Because I'm a juror, I'm only going to be able to remember like a few things, right? So what I wanted was like the PowerPoint slides to be kind of, the things that they're really picking up on and knowing like that stuff's extra important, okay? And so I had things where I had like little red flags. Like, again, the visuals were pretty basic, but, we talked about like, hey, if somebody comes to an ER with a headache and they don't have any sort of headache history, well, that's a red flag. This is a new event for them, right? And, that kind of stuff. So I tried to keep it pretty compact, I guess.
So let me ask you this, because now I've got an image of what you wanted to get across in your opening, just like a kind of a quick hit. What was the one thing you wanted to do in your jury selection? Obviously find the, people who could feel comfortable sitting on your case, but if you're looking to ask 1 or 2 questions, you did 2.5 hours on a med-mal case. What is the one thing you're trying to go in and do?
Establish credibility.
Beautiful.
Yeah, it was. I used the Nick Rowley brutal honesty, and then I borrowed a move from Chris, who, by the way, like, for everyone listening, like, Chris, I've learned a ton from you. So, and having watched one of your jury selections, Mike, was the case that you guys tried together. At one point, I was kind of talking about how, like, I wanted a fair fight, for lack of a better term. I didn't want anyone that was going to be unfair to us, but I didn't want anyone that was going to be unfair to the defense. We just want fair, open-minded, neutral folks. And I was like, I mean that. And at one point, as we got into things, somebody was like, hey, you asked for me to be brutally honest. And, brutal honesty, like, I've lost somebody recently and my heart hurts for your client. And I'm already leaning towards you guys without hearing, the evidence. And I said, well, thank you. And I'll be brutally honest with you. When we take a break or when we finish this process, I'm going to ask the judge to excuse you because it wouldn't be fair to the other side if you are already, leaning in our direction. Do you understand? And he said, yes. And that's what I picked up from Chris. Chris, I've seen you do that before. And for me, man, it's just actions speak louder than words, right? So that is an example to show the action of you mean what you say.
Yep.
And obviously, like that person was probably going to be stricken anyway, right? 100%. So it's not like you're losing a lot.
And you're speeding it up for them. And also you're relieving some pressure off yourself.
Sure.
About, I don't want that person to say too much. It's like sometimes we have to take that step back of like, hey, there's another lawyer on the other side who's not a complete idiot who just heard what was said. Like this is
they're coming off. They're coming off, right? And so it's funny because I know exactly the moment you're talking about when Chris did that.
Mm-hmm.
The other side was like, "Wait, what?
What?
Heads whipped
Wait,
out.
what?
Is that allowed? Can you do that?
Can you just strike someone on your own case?"
Yeah,
that's good.
So yeah, there's no objection. It went fine. And I mean, the other thing too is, in terms of credibility, like what I wanted, I was like, hey, this is a sad case. Like whoever is selected here, or I don't know if I said selected, but whoever makes it on the jury is going to be sad listening to this evidence. My client lost her daughter. But we don't want your sympathy. We don't. I mean that. Like, we want you to listen to the evidence and apply it to the law. On the other hand, we don't want anyone deciding based on sympathy for the doctor. And mind you, like, this is a good doctor who's probably done a world of good for a ton of patients. This case is about carefully and thoughtfully, judging his decision making on this one patient encounter.
Sure. Who here's in voir dire?
Yes, this is in voir dire.
Gotcha.
Right? Who here thinks they can do that, or who here thinks they're gonna think that his whole career's on trial and maybe be thinking with sympathy, and so I that stuff went really well in jury selection, and I really did feel that I had a good connection with the jurors.
You're listening to the Case Autopsy, the Verdict and Settlement podcast. This is Mike Campbell.
Thanks for listening to the first part of Nolan Drafahl's interview. We're going to have part 2 coming up in episode 16. Hope you'll stick around for that, and we'll see you next time.
That concludes another episode of Case Autopsy, the Verdict and Settlement podcast, part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.